A lot of people have asked me to do a video on the draft expropriation bill. I am definitely no legal expert, but I have read it and this is what I understand. In short, this bill will enable government to expropriate land without compensation as early as Q2 of 2019. For the state to expropriate land without compensation, two things needs to happen. Firstly, the constitution needs to be amended. The constitutional amendment will be presented to Parliament on the 31st of March 2019. Secondly, legislation needs to be written into law on how expropriations are allowed to take place. The draft expropriation bill deals with the legislative aspect. Public comment on this bill closes on the 19th of February 2019, and it is expected that it will be presented to Parliament soon thereafter. So, both this bill and the constitutional amendment will be settled by Q2 of 2019. Section 1 deals with definitions. Minister means the Minister of Public Works. Currently it is this guy, Mr. Tulas Ngezi. Organ of State means an organ of state as defined in Section 239 of the Constitution. This definition is any department of state or administration in the national, provincial or local sphere of government. Basically, organ of state means any person working for government. Property means property as contemplated in Section 25 of the Constitution. Section 25 speaks about land in the broader context, but subsection 4b clearly states that property is not limited to land. Public interest includes the nation's commitment to land reform and reforms to bring about equitable access to all South Africa's natural resources in order to redress the results of past racial discriminatory laws or practices. Section 3 subsections 1 and 2 states that the Minister of Public Works is the expropriation authority and that it is his duty to expropriate land on behalf of the organs of state. So, any organ of state has the power to file for an expropriation, and it is the Minister's duty to sign it off. Section 7 tells us that the landowner will be served with a Notice of Intention to Expropriate letter by the Minister, on which a date of expropriation will appear. In Section 3, subsection 5a, it says that the organ of state becomes the legal owner of the property on the date of expropriation as it appears on the notice to expropriate. Since the state is then the legal owner of said property, the dispossessed can then be evicted and the onus is on him to prove in a court of law that his case was treated unfairly. If government decided to radically implement these land reform measures, the courts will instantly be overrun with claims. It might be decades before your case gets heard. In the cases where compensation is due to the owner but have not been paid for any reason whatsoever, the state will still become the legal owner of the land. Again, the onus is on the dispossessed to approach the courts to retrieve his money. So, even if the constitutional amendment does not pass, this bill can still be used to expropriate land without compensating the owners. We have all seen how the ANC can abuse the court processes to delay cases indefinitely, and I fear that this will be exactly what will happen should this bill pass. The mainstream media propaganda machine is out there telling us that the bill only permits zero compensation in 5 extreme cases, and that private property rights are safe. This is not true. Section 12 subsection 3 clearly states that no compensation includes but is not limited to these 5 cases. Happy New Year! No, but seriously, wake up! Yes, nobody Klipkop.